Start. By this petition, the petitioner who has been convicted under the provisions of the Maharashtra Control of Organized Crime Act 1999 is seeking his premature release on account of the remission policy dated 10th January 2006, which was prevailing on the date of his conviction dated 31/8/2012. The petitioner claims to have been complied with all the conditions of the policy of the year 2006, and thus the rejection by the respondent authorities is unjust, arbitrary, and is liable to be set aside. Para. The petitioner has been convicted for the offences under the provisions of the MCOC Act, wide judgment and order dated 31/8/2012. By the time the petitioner has served actual imprisonment for 14 years, the petitioner has completed 65 years of age, and he has been certified as weak by the medical board, making him eligible for availing the benefit of the policy of the year 2006. Para. The state is empowered to frame policy for premature release in terms of Section 59 of the Prisons Act 1894. Time to time, different policies for early release have been framed. Initially, the state government wide notification dated 31/12/1999 framed a special remission policy, particularly for a class of prisoners who have completed 65 years of age, weak, and had undergone 14 years of actual imprisonment. Later on, the said policy was revised. Wide notification dated 10/1/2006, which was prevailing on the date of conviction of the petitioner. The said policy similarly provides for early release for those life convicts who have undergone 14 years of actual imprisonment, completed 65 years of age, and were physically weak. However, the policy has some inbuilt exceptions, stating that the policy would not apply to the convicts of specific enactments stated therein. Para. Wide notification dated 1/12/2015, Rule 6 of the Maharashtra Prisons Rules 1972 has been modified with addition of subclause 3 and 4 below subclause 2 of Rule 6. It has excluded applicability of the policy to the convicts under certain acts, including convicts under MCOC Act. The petitioner being a convict under MCOC Act, his urge for premature release was rejected in terms of the policy of the year 2015, which is subject matter of challenge. At the inception, it necessitates us to make brief reference of few admitted facts. The petitioner was convicted under different provisions of the MCOC Act, wide judgment and order dated 31/8/2012. The details of his conviction are set out in tabulator form herein above. The petitioner has completed 65 years of age, as well as undergone actual imprisonment for 14 years. Moreover, it is not in dispute that the medical board has certified that the petitioner is above 65 years of age and physically weak. The case of petitioner was referred to the advisory board for according benefits of premature release policy. The advisory board, in its meeting dated 11/11/2022, took a decision that the petitioner is not entitled for early release in terms of the modified rules of the year 2015. Being a convict under MCOC Act, the advisory board concluded that the convicts under MCOC Act have been kept away from the benefits of the policy in terms of Rule 6 in bracket B4 bracket close of the 2015 policy. The state in its reply affidavit has equally stated that the petitioner's case was considered in terms of the notification dated 1/12/2015. However, the same excludes the convict under MCOC Act, and therefore the petitioner is not entitled for premature release. Stop.